So you may have heard about this thing called an effective date. And we get these questions all the time, and we find in records all the time that the VA got the effective dates wrong. Now, to be clear, before I go any further, please note these discussions and examples are for illustration, and I've simplified the concepts to explain it to you. The effective date is the date the VA uses as a start for the veteran's disability benefits. And this is important because it often determines how much a veteran will receive in accrued or retroactive benefits, also known as back pay. So when a veteran hires an accredited VA benefits attorney, such as myself, they should be looking for ways to get an earlier effective date for the claims in the claims file. But let's look at some of the things that the accredited VA benefits attorney looks for. The basics on effective date are this. When a veteran applies for VA disability benefits, it establishes the effective date as the date the VA received the application. Or if there was an intent to file filed within a year prior, it'll take that date instead. Now, since it can take several months for the VA to grant disability benefits, the VA will first pay all of the benefits accrued since the date of the application until the date decision, and they pay a monthly benefit going forwards. Now, to understand effective dates, it's also important to understand when a rating decision, which is that decision that comes at the end of the process, becomes final. When the VA issues one of these rating decisions, the veteran has a year to appeal it before it becomes final. Once the decision is final, the veteran can reopen the claim after that 1 year period if they file a supplemental claim with new and relevant evidence under the Appeal Modernization Act. So here's an example timeline that I want to give you. Let's say October 8th, 2018, and the veteran files a claim for back pain. The VA issues a rating decision on February 20th, 2019, denying the claim. On February 18th, 2020, now nearly a year later, the veteran files a supplemental claim with new and relevant evidence. The VA issues a rating decision on May 20th, 2020, granting the back pain disability with an effective date of October 18th, 2018. So they're going to get nearly 2 years worth of back pay. Now let's change the facts a little bit. If the veteran had waited just a few more days to submit that supplemental claim, it might look like this. October 8th, 2018, the veteran files that claim for back pain. February 20th, 2019, the VA issues a rating decision denying that claim. February 28th, 2020, the veteran files a supplemental claim with new and relevant evidence. June 1st, the VA issues a rating decision granting the back pain disability with an effective date of February 28th, 2020. This happens because the veteran waited just a few more days to appeal with a supplemental claim. The original claim became final and had to be reopened. The veteran therefore lost out on potentially 16 months worth of back pay. This could be tens of thousands of dollars. Now, for the most part, when a claim is reopened more than a year after the rating decision, the effective date becomes the date the supplemental claim form was received. It is therefore really important not to wait to appeal if you aren't happy with your rating decision. Now, why is this important? Quite often, after several appeals and going back and forth with the VA will finally get a condition service connected and even rate it at the proper rating. But they might not even notice that the effective date is correct. They are so happy that they got that number and that future payments. But they forget that they might be entitled to years of back pay. Now, it's important the veteran look at this because this can translate into thousands or tens of thousands of dollars in VA benefits that they should have been receiving all along. Now, I mentioned the general rule earlier, but here's some exceptions because figuring out the effective date is not always straightforward. So here's some common examples that can trigger an earlier effective date prior to the claim or supplemental claim to reopen a decision that had previously become final. Let's talk about recent discharges. One of the exceptions to the rule about the date the claim was received by the VA is when the claim was received within 1 year of separating from service. Claims received within 1 year of service are backdated to the date the veteran was discharged from service. This is one of the many reasons why it makes sense to apply for disability benefits either right before or right after you get off active duty. Now, another exception is appeals under the Appeals Modernization Act, which went into effect in 2019. Appealing an incorrect rating decision, either because the rating was too low or the VA denied service connection for the disability altogether, preserves the effective date of the claim if the rating decision is appealed within that 1 year. Again, that original effective date is preserved if the veteran continuously pursues their claim, meaning they are continuing to appeal or within 1 year. So here's an example. Let's say October 3rd, 2018, the veteran files an intent to file. January 5th, 2019, the veteran applies for arthritis in their knee, and the VA issues a rating decision on May 23rd, 2019, denying that service connection. August 6th, 2019, the veteran files a supplemental claim with their personal physician's medical opinion and additional evidence. November 10th, 2019, the VA issues a rating decision, again denying service connection. December 1st, 2019, the veteran files a higher level review. After a higher level review on March 3rd, 2020, the VA issues a rating decision granting service connection at 10% disabling. In the above case, the veteran should get an effective date all the way back to October 3rd, 2018. This is because they consistently appealed in a timely manner. Another exception is the pending claims doctrine. Pending claims doctrine can get super complicated. In short, if you apply for something and the VA fails to adjudicate it, and the veteran goes back and applies for that same benefit later on, the veteran may be entitled for that earlier effective date. Here's an example. October 19th, 2013, the veteran files for arthritis in their knee, tinnitus, and PTSD. March 3rd, 2014, the VA issues a rating decision granting service connection for arthritis in their knee and PTSD, but doesn't mention tinnitus. It's like they just forgot about it. January 9th, 2017, veteran files another claim for tinnitus. April 14th, 2017, the veteran grants service connection for tinnitus. In this case, the effective date for tinnitus would be October 19th, 2013, and that amounts to nearly 4 years of back pay. And that's all because the VA forgot to adjudicate the original tinnitus claim back when the appeal was first pending. Another exception is the new evidence rule under 38 CFR 3.156, and this can be used in a couple different ways. First, in a pending legacy claim, which are all claims with a rating decision prior to February 19th, 2019, the VA should have reevaluate the decision if they received new and material evidence within 1 year of that rating decision. They have to make a determination whether it was new material, and if they don't, it's still pending. Right? Now there's a case, Lang v. Wilkie, which declared that records that the Veterans Health Administration has are constructively in the possession of the Veterans Benefits Administration. This gets really complicated, but if you were treated at the VA for your condition that was denied, you may have new and material evidence in there. Another subsection of this rule, though, deals with service department records. The VA's duty to assist requires the VA to retrieve service department records if you give them enough information to find them when you apply for benefits. Sometimes the VA just doesn't get them for you. Maybe they forgot to pull all the medical records, or if you had multiple periods of active duty, they only retrieved one and didn't notice that they only retrieved one. I've seen this happen a bunch of times where someone applies for something 20 years ago, only half the service records come in, but then we apply again now and the rest of the service records come in. It gets complicated. Now, if additional service department records are associated with the file later on, it's considered as if they were with the file all along, and they go all the way back to that first effective date. And again, this can be huge. This can mean years of back pay because the VA was supposed to have those records the entire time. There are some exceptions to this rule. It gets super complicated, but something to think about. Another exception is total disability for an individual unemployability, or TDIU, which I discuss elsewhere. Again, it's important to understand that TDIU is not a claim by itself, but rather part of the VA's duty to award the highest possible benefits supported by the facts. According to Rice v. Shinseki, which is a case from a number of years ago, the effective date for a veteran's TDIU award can be years prior to the submission of the form VA 218940 if the VA received information that the veteran was unemployed when the appeal was pending. Again, we've seen several cases where the veteran has been awarded TDIU, but the VA has set an effective date that does not go back nearly far enough. And the only way to find out whether this is the case is a thorough review of the claims file to figure out what evidence was in the file when and what benefits were granted when. Another exception to think about are these informal claims, which stopped happening after March 24th, 2015. An informal claim is basically any kind of indication that the veteran was applying for a benefit. So right now, if you apply for a benefit, you have to use a specific form like the 21-526EZ. But back before March 24th, 2015, if you sent a letter saying, I want to apply for my knee condition, that was a claim, even though it was on the right form. This changed after March 24th, 2015, because the VA was realizing that it was missing a whole bunch of claims. Now, according to Shea v. Wilkie, the veteran could raise an informal claim by merely pointing out medical records if those records contained a reasonably ascertainable diagnosis of a disability. So, if you maybe applied for diabetes back in 2012, that included all of the conditions that are associated with diabetes if those are in your records. If you applied for PTSD, that might also include TBI. If you applied for a knee condition, that might be arthritis or a strain, what have you. It could be a bunch of different things. So this is where it gets really tricky, and the only way to figure out if you have one of these informal claims is, again, that deep dive on the file. Now, as I've said, veterans are often thrilled just to get their disability rating after years of appealing. Or they've applied once, they got denied, and they don't want to appeal at all anymore. But one of the most important things they can do is apply for benefits early and appeal quickly and soon thereafter, because it gets harder and harder to get these effective dates the further you go out. As an experienced veterans benefits attorney, my goal is to get you the earliest possible effective date and the most amount of back pay possible. The only way to do that is by doing a deep dive in your file and doing a thorough review. We look for pending claims. We look for new material or new relevant evidence under 3.156C and B. We look for TDIU claims. Lots of stuff in there that might get you that earlier effective date. If you think you may be entitled to an earlier effective date, reach out and let's see if we can craft a strategy for an appeal. Until then, stay tuned for other videos on the Veterans Disability Benefit System.